his very
Yes.
close friend. He was president of the Law School Global League
Global.
until,
Yes.
and we also are founding member as Cattolica as some other universities. So
Excellent, excellent. I
cooperate
teach a
with
course.
our-
Yeah, I teach a course there. I teach a course at Cattolica on the UN. So I know Gonzalo and his team, and it's an excellent program.
Yeah, excellent partnership already for, well, I will say for 11 years since we begin the Jindal Global Law School. And we are
Very
proud
good.
to say we are now the top private law school in South Asia, not only in India. In the latest QS ranking, our law school was 75th in the world, already in the world, not just in Asia. So it's a tremendous achievement. We are very proud to have you, Patricia, with us. Maybe Ankit mentioned the idea of a book out of those lectures. So your experience in the International Law Commission will be absolutely necessary for that book. We will talk about this later.
Sure.
Unfortunately, the timing now is examination time in the Jindal University, and I know students are busy writing their papers. I see Surabhi Bandari, which is amazing to see, a good friend now and student who is graduating next year in the LLM program. Hi, Surabhi.
Hello, professors.
How have
Hope
you
you're
been?
well.
Hello.
I've been well, thank you. How are you?
Good. Is everything good with your exams?
Yes, all well. I just had one on Monday. I have one next week now.
Excellent. Okay, Patricia, you can start your talk. I hope most students join. They are not very precise.
We can, Professor Patricia, we'll post this on the YouTube. So can we?
Yes.
Are we allowed to do that?
Yes. Yes.
Sure.
Yes, please.
Okay.
We will have students watching the video recording, I'm sure, even if they're busy with the writing of their exams. But anyway, let me formally introduce Patricia Galvão Teles is a member of the UN ILC, professor of international law in the Autonomous University of Lisbon. She's also senior legal consultant at the Department of Legal Affairs with a long and distinguished career. She holds a PhD in international law from the Graduate Institute of International Studies in Geneva 2002 and a master's from the same institute in 1995, having graduated in law at the Faculty of Law at the University of Lisbon in 1993. Since 2002, Patricia has been a professor of international law at the Law and International Relations departments of the Autonomous University, and responsible for several undergraduate and graduate courses on international law, human rights, humanitarian law, and European Union law. She taught in several other Portuguese universities, military institutes, the Diplomatic Academy, and lectures frequently in Poland and abroad. In 2013, Professor Galvão Teles was Director of Studies of the Public International Law Session of the Hague Academy of International Law and member of the jury awarding the diploma in The Hague. Between 2008 and 2015, she was a legal advisor of the permanent representation of Portugal to the European Union in Brussels, where she was responsible for overseeing the implementation of the Treaty of Lisbon and other international and legal matters, including in relations to the European Court of Justice and the accession of the European Union to the European Convention of Human Rights, among others regarding the external relations of the European Union. From 2001 to 2008, she was a legal consultant on international law at the legal department of the Portuguese Foreign Ministry. Member of the Portuguese delegations to the 6th Committee of the UN General Assembly, to the Assembly of States Party of the ICC, and plenty of other bodies. The list is long. I will leave it here. My privilege and honor to welcome Professor Galvão Teles in the Jindal Global Law School for her lecture today. We are Very excited to be together. Hopefully one day soon, when travel resumes, we can host you, Patricia, to our campus in Sonipat, Haryana, hopefully very soon. Exactly, depending on the vaccination rate. In India, it's going well. So we hope that can happen even as early as next year. Okay, the format of the lecture is take your time. We don't have many students yet, but take your time, and I will say about 40 minutes, and then questions and answer session will follow up, moderated by Ankit Mahot. Once again, thank you very much, Patricia, for being with us. Your time starts now.
Thank you so much, Professor Vesselin. It's really a pleasure to be with you today and to be a part of the series of lectures organized by the Jindal Global Law School, which is also a partner of the global network of the global schools of law, where Católica University in Portugal is also a member, and where I have the honor to teach a course on the United Nations as a global legal forum. So I think we could not be more appropriate that we join efforts and collaborate and think of also future prospects. I also want to thank particularly Ankit for organizing and liaising with me, and then for his moderation of the discussion that will follow. I've had the pleasure of meeting Ankit in the framework of the Center for International Law of the National University of Singapore, which is also a partner in the global network of law schools. And Ankit has been a participant in the eAcademy that both Professor Nilofer Oral, who's been also a speaker in the series, and myself, we have created during the pandemic. And I think that we have to, and your example and this series is also a testimony to that. I think we have a responsibility to continue the conversation about international law, to continue training in international law, and to promote and disseminate important topics, even during the pandemic. And fortunately, due to technology, through Zoom or Teams, we're able to do that. And of course, I'll be with great pleasure with you in India sometimes, but in the future. But if or until that is possible, it's great that we do have all this new technology that allows us to be even far away, but together on the screen. So I'm very happy again to join you today. I'm very interested in several topics of international law. I think your very kind introduction, Professor Vesselin, has shown that I've worked on different areas. But when I was approached to pick a topic for this lecture, for many of my favorite topics and the topics that I work on in a regular basis, I thought I would pick the topic of state responsibility, the articles on state responsibility that were drafted by the International Law Commission, and which have now celebrated 20 years just very recently, and try to discuss the articles on state responsibility 20 years after. To put it perhaps more in the context of the topics and the general theme of this series of lectures, we could speak about reimagining the articles on state responsibility and the work of the International Law Commission 20 years after their adoption. So it is this exercise of taking stock of how we got to the articles on state responsibility, what has happened in the last 20 years, and what could happen in the future that I propose to discuss with you today. This has been, for me, a topic I have to say that I've been following since I was a student in Geneva. I had the chance to do a master's and a PhD in Geneva at the Graduate Institute of International Studies. And I could go to the Palais des Nations, where the Commission meets, and where now I have the honor to sit as a member, to watch some of the debates still during the first reading, leading up to the adoption of the Articles on State Responsibility, and the testimony that you have in the reports of the International Law Commission that reflect the debates at the time, at the end of the first reading, and then when the second reading was done. They do justice to the intensity of the discussion and the richness and the extremely high intellectual caliber of the discussion. But of course, nothing compares to being in the room and watching the members of the International Law Commission at the time discussing and seeing how this was a topic that not only was in the agenda in the Commission for such a long time, but also one that was the object of enormous attention from the outside world, but also within the Commission, and it was the topic that every year generated immense debates, and especially I remember very well, and this was still, as I mentioned, during the first reading, which was concluded in 1996, that there was this famous or infamous draft Article 19 on crimes of states that really drew very passionate debates, legally but also politically, and it was very, very interesting to follow. And of course, reading the annual reports of the Commission, and also a lot of literature that has been written, especially on draft Article 19 and what happened to it after the second reading. You can see how deep and how intense those discussions were. So I do have a strong attachment to this topic of the Articles on State Responsibility, starting with the work that I was doing as a student. I did my master's thesis at the time on obligations erga omnes, so the issue of crimes of state. So was something that was next to my topic, and of course that's how I became interested in the work of the Commission in this respect, and started following, even sometimes by going to the meetings of the Commission, because the plenary meetings are open to the public, and this is still true today. So if interested students are in Geneva during the month of May or the month of July, it is possible to watch the meetings of the Commission. And now also, because of technology, we started first broadcasting the audio of the plenary and public meetings of the Commission, and now also they are broadcasted also in video at the UN webcasts website. So it's possible also to follow, even if you're not in Geneva. So this has been rather long introduction, but just to explain why I wanted to reflect on the Articles on State Responsibility, which has been something, and I'll explain a little bit further, that I followed quite closely since my master's studies in Geneva, and then also that I followed after their adoption in 2001, when, as Professor Vesselin mentioned, I was a delegate on behalf of Portugal in the 6th Committee in New York at the UN, where on a periodical basis, the articles on state responsibility are discussed. The question of whether the articles should be or not a convention, an international convention, is still being discussed. There's going to be again next year. There's been, I'll explain that a little bit later, that what are called technical rollovers every 3 years. And so next year it will be again the period where the 6th Committee, which is the legal committee of the UN General Assembly, will have to discuss the matter once again. So this is something that has followed me since I was a student delegate in the 6th Committee, and now, of course, as a member of the Commission, although we are no longer working on the draft articles on state responsibility because the work has been concluded, and now the ball is on the court of member states in the 6th Committee. This has left, of course, in the Commission a significant impact in terms of the way that the Commission has positioned itself with regard to the forms it has chosen in respect of later topics. And this is a point that I'm going to make during my presentation. But also it has left a mark also in opening up a certain room for closely related topics that have not been yet dealt with. And of course, some of these developments took place before I became a member of the Commission, but it's worth recalling that since the articles on state responsibility were adopted in 2001, the Commission has also worked on the topic of diplomatic protection, which is very closely related to the topic of state responsibility. I remember very well my first courses in international responsibility. We were taught that there's a part where there's a state-to-state relation with regard to state responsibility, but there's also the possibility that a state takes up a claim of a citizen and brings it to another state in the exercise of the so-called diplomatic protection. And the Commission has also produced a set of draft articles concluded in 2006, if my memory is correct. And so this is another topic that is closely related to state responsibility. And then, of course, a little bit later, finishing in 2011, the Commission has drafted a set of articles that are parallel to the articles on state responsibility on the responsibility of international organizations, which is also a very interesting development. The area of international organizations is, of course, more and more important. International organizations are more and more relevant actors in international law, and sometimes the rules are not as clear or are not as developed as they are when it comes to regulation of state behavior. So it was very interesting, although I have to say at the time I followed it as a 6th Committee delegate, that there were many discussions on whether the area was ripe for the work of codification and progressive development, and whether it was possible to generalize rules that apply in a state-to-state relationship to the international organizations area, especially bearing in mind that international organizations are very different one from each other. So that was, I think, an important difficulty how to overcome the fact that when you're dealing with states, states are organized in the same way. They're legally there's the principle of the sovereign equality, and they're legally the same. They have the same place. They have the same spot. There are no differences. Of course, we have big states, small states, powerful states, states that are more prone to be committing wrongful acts, others that are more prone to be suffering the consequences of wrongful acts committed by others. But there is no difference in the nature of states, and so it's easier to find those rules. And of course, the practice was much richer. And when it comes to international organizations, it is not only clear that international organizations, although they've existed for over 100 years now, but the great developments happen after the creation of the United Nations, and in the last 75 years, it's where we've had an intensity of multiplication of international organizations and also regional organizations. It's where also we had an increase in the types of activities of international organizations, and so the practice is a practice of 100 or 75 years, whereas for states it's a much larger, longer practice. And then there's also the difficulty that I was mentioning earlier, which is the fact that international organizations are created by treaty, and they are very different. They're very different in their structure, they're very different in their powers, they're very different in their activities. The relationship between the members and the international organization is also very different from organization to organization, depending on what the founding treaties stipulate. There's one particular organization which has more integration and where the questions of responsibility also might be different, which is the case of the European Union, which is also an organization that I know well, not only because Portugal, of course, is a member of the European Union, but also because, as it was mentioned in the introduction, I was also posted as a legal advisor to the Portuguese mission, permanent representation to the European Union in Brussels, and I could see on a day-to-day basis these issues of the articulation between the competences of the organization and the competences of the member states, and to whom responsibility could be attributed. So you have one organization perhaps with more practice, but with rules that are much more integrated than, for example, the United Nations or other intergovernmental organizations. So this was also an interesting project, I think, with its own specificities and difficulties that I just mentioned, that the Commission has taken up and finalized 10 years ago. And again, it's also on the agenda of the Sixth Committee, and if there haven't been developments in turning in the direction of turning the articles on state responsibility into a convention, I mean, clearly having a convention on diplomatic protection or on responsibility of international organizations is even more far down the line, because I don't think that would ever happen if we don't have first a convention on state responsibility. So in a way, those other topics are highly dependent on the fate of the articles on state responsibility. And even I think I'm probably of the view that even if one day member states would decide to negotiate a convention on state responsibility, it's not necessarily the case that the other topics would be turned into a convention afterwards. So I think we have to separate a little bit. Then, of course, there's still some room for working on areas that are related to state responsibility, and that's also part of the inheritance that I was mentioning before, that we feel in the in the Commission. And one of the best examples is the fact that currently on the agenda of the Commission, there is a topic which is called state succession in relation to state responsibility, which is a topic that is still in the phase of the first reading. This was a topic that was put on the agenda in the year I joined the Commission in 2017, and we've been working under the leadership of the Special Rapporteur, Pavel Sturma, and it's still not clear that first reading will be possible in the very near future. And so this is something that still has to be followed. It's hard to say exactly what would be the precise outcome of this work, but I wanted to highlight it because it's well, not only the Commission had worked already also on the topic of state succession, because it has produced a number of drafts that then became international conventions on the issue of succession with regard to treaties, and succession with regard to property, archives, and debts of the states. But also now it has linked these two areas where it had worked before, state responsibility and state succession, and we are trying to work on rules that, of course, in many cases will be have to be tailored to the specific case, because each case of state succession is different, depending whether the predecessor state continues to exist or not, and so it's very difficult to find. And of course, one of the things that we did in this project earlier on was to admit that states are free to negotiate how they want to handle questions of state responsibility in instances of state succession. So there's a principle that this will be done by recognition, that in practice this is normally done by agreement between the relevant parties, and only if necessary, then we have these default rules that we are developing, and they also reflect the different types of succession that can be then used by states as an inspiration or as a background or as default rules if there's no other agreement. So of course, what I'm saying, and I think it's quite clear, and it's probably no surprise that there's been a huge impact in terms of the inheritance that the work on state responsibility has left in the Commission, and this is I think even more far-reaching with what I'm going to try to explain afterwards. But so one of the things I also wanted just to put in context, I mean, I'm sure that many of you are familiar with the work of the International Law Commission, with its mandate. It is a mandate of codification and progressive development. The fact that the Commission has been created by the General Assembly, so that the General Assembly can fulfill its mission that was given to it by Article 13 of the Charter, to promote the codification and the progressive development of international law. So the International Law Commission was created under that competence of the General Assembly given by the Charter, and it was created as a subsidiary organ of the General Assembly, composed by independent experts, of course, appointed by their countries, but appointed then, once elected, serve on the Commission as independent experts. And what we do is we prepare drafts that can be draft conventions, draft articles, but also other types of instruments that I'll explain in a while for the consideration of the General Assembly. So the Commission is very well placed in the center of the system, and in the center of the system of the UN as a body that interacts directly with six committee and with member states. And in that aspect, although there are other bodies that have been doing also extremely relevant work and are even older in historical terms than the Commission, like, for example, the International Law Association or the Institute of International Law, that are private bodies. They are learned societies that also have a mandate that is similar to the International Law Commission, in the sense that they can also work, and they do work, and have done extremely relevant work for the development of international law and its codification. The main difference, of course, with the International Law Commission is that the International Law Commission reports on an yearly basis to the member states, gets input from member states when also on a yearly basis the member states discuss in the context of the Sixth Committee the report of the International Law Commission. There are requests for written comments, and there's also an important period, which is the period between when the Commission finishes a first reading, and then there's normally a lapse of 1 year, but it can be longer, and in the case of state responsibility, it was longer. But there's a lapse where states have an opportunity to comment on the full project that was adopted by the Commission on first reading, and then the Commission comes back, and before finishing the second reading, so the final reading, takes into account the comments that were made by states. So there is a very intense relationship, and that's different than the other similar bodies, to which I also am very honored to be part also of the International Law Association and also of the Institute of International Law. But this relationship with member states is certainly different. It also affects, to some extent, the way that the work is done, in terms of being something that is not an academic exercise. It's not a merely academic exercise, but something that is supposed to be of interest to member states, that takes into account state practice, it takes into account the views of member states. And of course, when the Commission, now going a little bit back in history, when the Commission was created in 1948 by the General Assembly, one of the first things that was done was a study by the Secretariat, a memorandum by the Secretariat, trying to identify the main areas that would be ripe for the mandate of the Commission, for the mandate of codification and progressive development of international law. And in that memorandum from 1949, many topics appeared. It was a survey. It was a survey that was done by the Secretariat to try to shed some light on the topics that could be brought to the agenda of the International Law Commission. And of course, many of the topics that are listed in that survey are certainly not a surprise to you, because they were topics that were that the Commission worked on right from the beginning, and that have then become major international conventions that regulate central areas of international relations. And I'm talking, for example, of the draft articles that were prepared by the Commission in the 50s and early 60s on, for example, diplomatic and consular relations that then were the object of discussion in a diplomatic conference and led to the adoption of the Vienna Conventions on Diplomatic Relations and Consular Relations, the first one of 1961, the second one 1963. And I normally like to say that these two conventions on diplomatic relations and consular relations are probably the best sellers, the most accomplished products of the Commission, not only because they were done quite quickly, they were turned into international conventions also quite quickly, and they have almost universal adherence. So if you look at the table of ratifications of both conventions, they are highly ratified, nearly universal acceptance. There haven't been changes, revision processes. I mean, they've lasted, and they are both more than 50 years old now, and they've stood well the test of time. They are also, both of them, complemented by optional protocols that recognize the competence, the jurisdiction and competence of the International Court of Justice, which is also, very significant, of course, as an opt-in instrument. But there are a number of states that also have accepted the competence of the International Court of Justice to deal with questions related to the interpretation or application of these two conventions. And we do have a number of cases that have been brought to the International Court of Justice based on these optional protocols relating both to diplomatic and consular issues. So it's, for me, I think one of, on balance, when we look at the history of the work of the Commission, and then the buy-in from states, and then also the use as an instrument to settle disputes also at the International Court of Justice. This is probably, I think, the most successful example. But then, of course, we have the Vienna Convention on Law of Treaties, which is the other, I think, great product from the 60s by the Commission. Of course, with a more mixed reaction, it took longer to come into force. There are less state parties. The referral to the ICJ is also more complex, but still, of course, we could not do without this convention as one of the pillars of international relations. Whether you're an academic, whether you're a legal advisor in the government, or whether you're a judge in an international court, it's certainly an instrument that you apply on a daily basis every time that you have to consider a treaty. And of course, with the sister convention that was also prepared by the Commission on treaties between states and international organizations, and between international organizations. So all these topics, they were identified in the 49 memorandum, and the Commission started working on them immediately and have come to a successful conclusion. One of the other topics, I'm not going to talk about all the other ones, but I was just highlighting some of the main ones. But of course, one of the other topics was the topic of state responsibility. It was there since the beginning in the Secretariat Memorandum of 49. But contrary to these other examples that I gave that were finished in the 60s or a little bit later, the topic of state responsibility took much longer, much longer to develop, perhaps because the practice maybe was not as clear as in other areas, because also the fact that the topic was taking a bit longer in time, it led to several special rapporteurs taking up the topic. It's not always easy to make a coherent use, also because the Commission is re-elected after 5 years, and not always we have the same people being re-elected. So sometimes there's inevitable change in special rapporteurs, and that also, creates sometimes the need for additional time, or things take a little bit longer. And so there have been many special rapporteurs dealing with this topic. And also probably, I think it's also fair to say that a lot of the practice regarding state responsibility was well established. So, there are aspects where there are clear rules that attempted to codify existing international law. But for example, the issue of that I evoked early on in the beginning of the talk about the former draft Article 19 on international crimes of state. It was something that was certainly not codification, an exercise of progressive development and progressive development of a very progressive kind, if I may say so, in the sense that we did have at the time important developments in terms of seeing how the international community was more and more recognizing that there were non-derogable norms, and that's the case of the jus cogens concept that was introduced in Article 53 of the Vienna Convention on the Law of Treaties. It was introduced initially in the draft prepared by the ILC, and then it stayed on during the diplomatic conference. It was also the case during the 70s with the Barcelona traction case of the recognition of this idea of obligations ergo omnes, that obligations then have to be fulfilled by every state, and also that every state has an interest in the fulfilling of those obligations. So we started, I think, having bit by bit a recognition that there was some kind of a vertical approach in international law, or that there was some idea that there were community interests that should be protected, and norms that were more important than others, obligations that were the concern of all states, a number of norms that coincided between the different concepts in terms of the prohibition of the use of force, issue of self-determination, human rights. And I think it was inspired by these developments that the Commission, in its discussions during the first reading, decided to take the extra step of trying to add here an additional category of verticality and protection of community interests, which is the category of crimes of states, thinking that with this would reinforce, of course, international law and how to deal with the reactions to the most serious violations of these most important norms of international law. Of course, this generated an important backlash from states. It was highly discussed in the doctrine. It stayed on until the end of the first reading. So the text from 1996 still has the reference to this draft Article 19 on crimes of states. But then when the Commission adopted the first reading, and then there was a change in its composition, and there was a change in the special rapporteur when there were elections at that time, and there was a new special rapporteur that was appointed at the time, Professor James Crawford, that then, of course, everybody knows became Judge Crawford, and unfortunately, Judge Crawford passed away at the end of May this year, and is somebody who certainly left a great mark in the Commission, not only because of his work as Special Rapporteur on state responsibility, who concluded the second reading, but also because he had worked on the preparation of a draft statute for an international criminal court, which is something also that the Commission did. So James Crawford was instrumental in the second reading process, and one of the things that I think became clear to the Commission at the time was that it would not be acceptable for states to have draft Article 19 on international crimes of states, with the argument that crimes are committed, so the Nuremberg Tribunal argument that crimes are committed by individuals and not by abstract entities such as states. In international law, the criminal responsibility is for individuals and not for states. But then at the same time, that international law, I think this is how the special rapporteur, James Crawford, but also many other members of the Commission approached the issue. At the same time, we could not have the articles on state responsibility as something that would just recognize interests that are protected in a bilateral sense, in the sense that there has to be some recognition that there are some norms that merit a special regime of state responsibility, and I think in the end this is what we have in important parts of the draft articles, namely when we come to the section that deals with the consequences of state responsibility, and we have the notion that there are serious breaches of obligations under peremptory norms of general international law. So peremptory norms is, of course, jus cogens. And so Articles 40 and following, they establish a special regime for serious breaches of jus cogens norms that have to do with obligations on third states, for example, the obligation of non-recognition as lawful of a situation that is contrary to jus cogens, that was done in breach of jus cogens, or, for example, with regard to the issue of the invocation of responsibility, namely Article 48, that allows for invocation of responsibility by a state other than the injured state. So Article 19 did not survive the second reading, and the idea of crimes of states disappeared from the draft. But this idea that there are serious breaches of peremptory norms, and that these serious breaches entail different consequences, so more serious consequences besides the normal consequences, and also that there are there's a wider number of states, including third states, non-injured states, that can invoke responsibility. Was a very important achievement, I think, by the Commission, and a way to overcome the difficulty that the responsibility of the notion of crimes of states had generated. So the second reading was a complex exercise. Not only because this important element needed to be, that reflected what I was calling the verticality or the community interest approach. This element needed to be preserved, but also, and this is the point that I want to explore next, also because there was already during the second reading, and especially towards the end of the second reading, an important discussion about already within the Commission, whether the articles that the Commission was preparing and was about to finalize in second reading should become a convention or not. So this debate, and that's why when I'm thinking about reimagining the articles on state responsibility 20 years later, we need to go back. I think we need to go back to this moment because, the question 20 years later is why, or the questions that can be asked is why have the articles not yet become a convention? Or why have the path of keeping the articles just as articles of the Commission that were taken out in the Sixth Committee General Assembly resolution, why has that been the path that has been chosen so far, and where or how did this whole approach started? Because if we look at the, and I'm not going to bore you with the details or numbers, but I wrote, because the articles on state responsibility, they turned on the side of the Commission, they were adopted in early August 2001. And so Agile Talk did a symposium in August to commemorate the 20 years of the articles and the achievement of the work of the Commission. And I wrote an article for that symposium where I tried to explain how this has meant a significant change in the practice of the Commission, because the Commission in the past that basically worked in terms of preparing international drafts for texts that later became conventions, and this was the normal way and normal method of work. And what we have now is that we have the articles on state responsibility that 20 years later are still not yet the convention, where the Commission innovated, and I think that was a bit of the compromise that was done at the time that the Commission innovated, in the sense that it decided to have a two-step approach, which was the first time that it had happened. So instead of recommending normally what the Commission, when the Commission thinks that it has draft articles that will become a convention, the Commission recommends to states that the convention should be negotiated on the basis of the draft prepared by the Commission. And this is what happened, for example, most recently in 2019 with the articles, the draft articles on crimes against humanity. In this case, and I think also because of the debate that emerged still in the ILC at the time before the end of the second reading, and because of the solution, the compromise solution that was found in terms of this two-step approach of the Commission first proposing that the General Assembly take note of the draft article, so simply take notes, and only at a later stage consider whether the articles should become a convention. And this has led, I think, to the situation that we still have today, where the Sixth Committee is still debating whether to turn this a convention or not. And because of the impact that the articles on state responsibility have had already during their preparation in the Sixth Committee, but clearly in the last 20 years, and how much international courts and tribunals have used the draft articles almost as if they were a convention. There are, I think, the Secretariat, the UN Secretariat does an update every 3 years for preparation of the debate of a list of cases where this where the articles have been invoked, and and from the ICJ to arbitration tribunals, investment arbitration. Also, the articles have been invoked more than 300 decisions. So there's a real impact, and that's of course without counting the impact it has also from the point of view of states that regularly revert on their day-to-day practice to the articles on state responsibility. So we've had clearly an impact, even though the articles have not yet been transformed in a convention, and this is, I think, because of the hesitations that started in the Commission itself, and then they transpired into states. The hesitation of whether a convention on state responsibility would be a convention that would cover all disputes, because almost every dispute between states is a dispute where there's some question of state responsibility involved. Whether, for example, another fear that was pointed still in the Commission, and then it's echoed by states when this debate happens, is whether a negotiation, whether at the UN or in the framework of a diplomatic conference, would unravel the articles, would unravel the work that the Commission has done, or whether it would the outcome would be weaker, or would be, the balance would be disturbed between regarding what was achieved by the Commission. So there are many points that have been weighing in, I think, both already in the debates in the Commission and also now in the debates in the Sixth Committee every 3 years that have led to hesitation since 2001. And of course, one could think that now we're in a moment where there's maybe some treaty fatigue and not appetite by member states for new treaties. I think this is something that in the last 5-10 years, certainly we've felt that, especially I would say last 5 years, where there's certain, I've called it stagnation of treaty making. But even before that, I think, if we go earlier to 2001, 2010, maybe that problem was not there. But it is a fact. It is a fact that every 3 years, since 2001, the Sixth Committee debates this issue and postpones the discussion. So the so-called technical rollovers postpones the action for 3 years later. Of course, this is not very, I think, the fact that we have this technical rollovers is not very conducive to a serious debate, to a deep debate, because it's only a limited number of days that the issue comes to the discussion in the Sixth Committee. There's a lot of, in the Sixth Committee, the legal advisors that are in New York, or the ones that come from Capitol, they tend to change a lot. So I have a bit the impression, if I can speak in a frank way, that every 3 years we start the discussion from scratch, even though there's always some there's things that have been written in academia, and there's some side events to promote discussion and to try to prepare delegations better. But it seems that we start to certainly, for most people, that we start the discussion from scratch, so we don't go very far every year. We stay in terms of discussion more, in the pros and cons, more at the general level. I don't think there's been yet an exercise that has been done fully to try to at least create a forum where the issues could be discussed in a more detailed way, and in also in a more continuous way, rather than coming back every 3 years. So because in the near future, I don't think it's possible to envisage that this will become, this is my You know, after many years of following this and knowing how the UN works, I don't think that in the next 10, 15 years, I don't think we will have a convention. It's still very important to continue to discuss the content of the articles, to understand why they've shaped so much the law of state responsibility, and how they're being used by international courts and tribunals. And it's also in that spirit that together with another colleague, Professor Pierre Baudot-Livinec, who's also been following this issue for a long time, we thought it would be interesting, and we've made that proposal, and there's a book on the way. Maybe a bit unorthodox, but we've decided to do, and I make here some publicity, if I may, but just to let you know, and so that you can be attentive when it comes out. It will be coming out sometime later next year. But we've decided to prepare a commentary on the articles on state responsibility. So normally you do a commentary when you have a convention, and in this case there's no convention, but we still think that this instrument is significant enough, and there's enormous practice that developed in the last 20 years that we've decided to do a commentary, which will be published by Oxford University Press, and where the leading authors in the area of state responsibility will comment on each article, a bit to see and a bit to help the process of reflection and see how the articles, article by article, have been applied in practice by states and by international courts and tribunals in the last 20 years. The last point, I don't know how we're doing in terms of time. I think I should wrap up soon.
Please take your time, Professor.
Yeah. Okay.
No hurry.
Okay. I just want to finish with this last reflection on what this has meant for international lawmaking, also in a way, because of the situation that I described, the fact that we've had the articles that have not yet been transformed into a convention, but that are followed and are applied by states and tribunals and courts. Some people speak about, and the doctrine has been very, and the academic debate's very rich on this. Some people speak about codification light, soft codification, non-legislative codification. The late David Caron wrote already some time ago an article on the American Society of International Law journal on the AGIL, talking about the paradox between form and authority. And I think this is important, and an important debate, not only just because of state responsibility, because of the subject, but also more broadly on the question of international law making, how international law is made. Because here we have a draft that was done by an expert body, that was not then negotiated as a convention, but still has a very significant impact. Most likely, many of the articles reflect customary international law, so we could also argue that the articles are being applied because they reflect customary international law. But it's true that, and I think that's also one of the arguments in favor of a convention is the issue of ownership, state ownership of international lawmaking, and not having international law made by expert bodies. So that's why the architecture is one of, the ILC is the next expert body, and then delivery to the sixth committee, and then the states decide what they want to make. Here, there is a certain, if I can also speak in a frank way, I mean, a certain bypass of that process and a lack of ownership of states, sometimes in a very provocative way. Somebody has spoken once of a normative Ponzi scheme between the ILC and the ICJ, when, for example, there's an article in a draft article that is then applied by the International Court of Justice. Of course, neither the ILC nor the ICJ are lawmakers. States are the lawmakers. So I think we have to put this discussion into perspective also from the point of view of international lawmaking, and also from the point of view, and I'll end on that, for the future work of the Commission, because as I mentioned, there's been a significant impact on the work of the Commission, not only in terms of substance in the topics that I highlighted some time back, but also on the form of the products of the Commission. So since state responsibility, since this experience, and as the Commission has seen the evolution in the debates of the Sixth Committee, there's been some inclination in the Commission to work less in the format of draft articles and work more in the format of principles, conclusions, guidelines, that are exercises more of codification of international law that don't need then to be transformed by the states into a convention. There's an interesting approach recently by an academic in an article by Danai Azaria, where she speaks about codification by interpretation, that the Commission is doing a lot of interpretation of its own previous work. For example, the topic of use cogents that we're doing now, which we build on Article 53 of the Vienna Convention, or, for example, the topic that we've just finished on provisional application that builds on Article 25 of the Vienna Convention on the law of treaties. This influence that indirectly, I think, the articles on state responsibility had on the preference of a certain preference for the Commission to work not in terms of draft articles that may stay then in the Sixth Committee, but rather to produce conclusions, guidelines, principles, or studies. This, I think, is something also to be taken into account, especially when we think about the future of the Commission, and when we think about areas of international law that could offer themselves as good areas for work of the Commission. And I think that the Commission should think very carefully about future topics, about new topics, but also about the form, and try to go back. I know that, it's clear that as many say, the golden era of codification is over, and most areas of international law, general international law, that the Commission is comfortable in doing are already codified. But I think it's very important that the Commission also thinks, when choosing its topics, that it's good to have a mix of topics, not only in terms of more traditional topics, but also topics that meet that are relevant to the current challenges of the international community, but also some that are prepared as principles or conclusions or studies, but others that are prepared for becoming conventions, with the intention of becoming conventions, like it was the case, very clear from the beginning with regard to crimes against humanity. So I think I'll stop here. I don't know if I want to make a conclusion in reimagining. I tried to think, what if the articles had already been adopted as a convention? Maybe we wouldn't have this discussion today. But I think, of course, this is international law has its own specificities. It's also a testament to its vitality. It's more complex than producing national law, certainly. And this is part of how we imagine international law. So thank you very much for your attention, and I'm very happy to answer any questions that you may have or any comments that you may have. Thank you very much.
Well, let me begin by reciprocating the gratitude. It was quite riveting hearing you speak about these challenges and also reflections and also what might be coming in the future vis-a-vis state responsibility and the ILC largely. I have 3 points which I want to raise, and I'll raise them as and when they were spoken. So I'll start with the latest one and then move gradually upwards. The first point which I just wanted to raise is with respect to treaty fatigue. Now, treaty fatigue seems like a problematic perspective which states have unfortunately adopted, especially in the face of growing challenges like climate change, and more specifically what your academy was covering, especially in this week on global health and the creation of a pandemic treaty. What was highlighted in this week by the speaker was that there are only just 3 conventions vis-a-vis global health. It seems like an extremely low number when it comes to such an important issue, which cross-cuts all sectors of society and doesn't really differentiate between a poor and rich nation in terms of how it affects. In fact, richer nations have done more poorly whilst treating or taking care of pandemics, generally speaking as well. The other point which I wanted to raise is with respect to the golden generation, which you spoke about on the Vienna Convention on Consular Relations and the Vienna Convention on Diplomatic Relations. Now, this became the heart in the Jadhav case. Consular access was sought as a means to eventually bring back the fugitive charged with espionage. Now, what the ILC said on charges of espionage, you may not give consular access. So I was very curious to know where you would stand on a count wherein a common law principle, but a principle also enshrined in all sorts of legal systems of right to access to a lawyer, or just some sort of counsel, and in totality right to a fair trial. And no immunity can be exercised because of the charges put against him. Of course, immunity wasn't even argued, but nonetheless, I want to highlight that. The other point which I want to make is with respect to, it's on the same line with respect to health law and international state responsibility. Is there, in your experience, in these chambers and ecosystems of international diplomacy, is there any sort of chance that there might be some sort of an advisory opinion or some sort of a contentious case made against China or any other state responsible for the pandemic and its spread? Because I am aware that the international health regulations speak that the declaration might be made by the state to inform that this is the status quo. The other, and this I'll close with this, is with respect to ownership, which you spoke about, of international lawmaking. So I was very curious to know where does Portugal stand in this? So what are the essential tenets with which you as the Portuguese delegate speak about? So what are the concepts which are very close to you, which you want to represent in an international setting? I was also very curious to note and learn from you how India has fared in this, because India represents a perspective, it has an academic perspective of this on which starts from the self-determination movement, then goes to the Bandung conference, and then sort of formulates itself in a third world perspective. But as you very rightly said, that this ILC and even this international structure is not an academic exercise. TWAIL, in its very essence, is an academic perspective and an academic undertaking. But I'm very curious to see, have you, as an observer, as a member, noticed TWAIL aspects, or TWAIL in its entirety being represented or voiced heavily? Perhaps the representation of states in the ILC and how the voting works as well would play an instrumental role in this. So essentially, I'm speaking about Eastern Europe electing their own member, and then Western Europe electing their own member. So these were just a couple of pointers which I wanted you to address, and these were, of course, I'm thankful to you because these reflections come from whatever you've highlighted.
Professor, just to add a small point to the 3 points which he's made, how do you see the sovereign equality of various states being expressed now in the working of ILC in last 20 years? So what I mean to say is how much the independence of the states, especially those who are not so socially and economically well off or disadvantaged, how do you see their equality being expressed in the working?
Thank you. Thank you very much, Ankit and Abhinav, for the excellent questions. I think we could stay here for a long time because you've really, raised important questions and some that don't have an easy and simple answer. But I will try. I'll just very briefly to address the points that you made. Of course, speaking on a personal capacity and we are in the middle of an academic exercise, so of course I'm sharing my experience as member of the commission, but I'm not speaking on behalf of the commission, and I'm not speaking also on behalf of Portugal because there was a question, but I will share my experience, my personal views on the several points that were raised. The point on treaty fatigue and lack of appetite also, that I think we can call it. For me, it's something that worries me very much, and that's why I've been raising it, and I've been raising it also in a very critical manner, calling it stagnation in international lawmaking by treaty. And I had a very interesting discussion whether we're really in a stagnation period, or it's just inertia, or maybe it's just fatigue. But I even go for the maybe the more critical approach in saying that I think we are in a period of stagnation, and this is essentially due, I think, due to lack of political will, lack of the possibility of coming together and finding real global solutions for global problems. And the two examples that you gave, climate change and the pandemic, I think they are the best examples. Luckily, with climate change, we have the Paris Agreement. And the Paris Agreement of 2015, perhaps it's the very last big agreement that we've had. The last 6 years after that, there are some multilateral agreements. Of course, there's a lot of activity when we speak about lawmaking, international lawmaking. Of course, I think bilaterally things and regionally things are very active. They're very dynamic. States engaged. They're on a very active basis. There's lots of bilateral treaties, memorandums of understanding. I mean, there's a lot of activity at the bilateral level. What I'm talking really is at the multilateral level and at the UN level, the willingness to deal with major issues and putting a treaty at the center of the architecture. Of course, now what we see is a lot of soft law instruments also as a compensation for that lack of political will to commit to new rules. And that's good and bad. That's good as an alternative, but I think that's also bad because soft law is soft law, and then it's bad from the point of view that you may have then if there's a dispute, then it's unless you can argue that the rule has become customary international law, then you don't have a hard law instrument to apply. But that's also, I think, bad from the point of view of states that may be allowing, through the formation of customary international law, may be allowing international law to be formed. So I think sometimes states are not, when they don't want treaties, they don't realize fully that there's an opportunity to control more of the process in a way, you know, of accepting binding rules, being or not party of a treaty, and the fact that now we have soft law multiplying, that then maybe will become customary international law. Of course, it's a more diffuse, and you can argue yes or no, but I think it's also not to the advantage of states, and especially, you know, okay, now for climate change we have the Paris Agreement, and there's a lot that is being built on the Paris Agreement. And that's very positive, and that's you know, that was I think the last major development that we had in major topics. But I think we're missing that for pandemic for the pandemic, and it's clearly you know, something that is being discussed now. I'm not so sure. We'll see from next week what are the chances of a pandemic treaty. But it, you know, if you try to, and I have those discussions also with my students. When you think, you know, this is the major issue that is involving everybody from the common citizen to states to enterprises in every single country in the world, and there is not a single instrument that deals holistically with this issue. Of course, you can think, you know, it's better to legislate after the issue. You may argue that it's not the good moment to legislate when we are right in the middle of a pandemic. I think we are in a way one pandemic late because there were warnings, clear warnings that this was coming. And of course, I think the instruments that we have are good, like the international health regulations, but they're probably not enough to, you know, regulate and also to create a platform, a real platform for states to be able to have the instruments to deal with all the aspects to combat the pandemic that involve human rights, trade, access to vaccines, and so very, very, very broad. The second point on the question of the consular access, I mean, I would think that that's probably the spirit of the Vienna Convention, is that, and the spirit of the applicable human rights in principles too, is that regardless of the charges, you should always have access to a lawyer and the right to a fair trial. I mean, I think that's a question of principle. Of course, I mean, there are issues that are issues of state sovereignty, very close, the questions of espionage and state secrets, but I think they should not trump the principles that should ensure, as we have, I think, for in every legal system, the right to access to a lawyer and the right to a fair trial, that are basic principles also related to human dignity. On the question of state responsibility for the pandemic, and the issue that has been much discussed about whether we can bring any state, I mean China or any state, to the state responsibility of a state because of the pandemic. I think it's very, very difficult, very, very difficult in the sense, unless it's for specific issues, very specific issues. I mean, I see, of course, there's a problem of the forum. Where do you go to discuss? Of course, there's always, you know, the possibility of going through diplomatic means, negotiation. But if you're thinking about an international court, of course, there's always the problem, including the ICJ, the problem of jurisdiction. And so that would always be dependent on consent and making sure that the international adjudicatory body has jurisdiction. But I think there's also a substantive problem, which I think it's one of the most difficult questions in state responsibility nowadays, when you think about issues both like climate change or the pandemics, which is the question of attribution. In attribution, of course, you know, in the state responsibility rules, in order for one to say that there's responsibility for an internationally wrongful act, you have to establish that the act is wrongful at the international level, and then you have to establish that the act is attributable attributable to that state. And so these are, when you're thinking about, more traditional acts, maybe that's easier to establish the attribution, but in instances like the pandemic or climate change, I think that's a key issue that it's very difficult to solve in terms of the how do we attribute certain acts, especially if we're talking about a more general behavior. How do we attribute legally that act to a state? Then in terms of the question of ownership of international lawmaking and the position of states like Portugal or India or the 12 approach, I think I can say for a state like Portugal, and I don't think it's just a case of Portugal, I think that small, medium states see a great protection in international law. And international law is what protects us from, because we don't have military power, or we have short military power, and because of our geographical position or our dimension, I think international law is what protects us. And so that's why I think Portugal and other similar states have a very strong view in terms of the development of international law, and the development of international law also by treaty, in the sense, for example, in the discussions on state responsibility. Portugal has been since 2004, so the first discussion after the articles were adopted in the ILC, and then the GA took note in 2001 when we started discussing, the faith of the articles and whether to turn them or not into a convention. Portugal has been always a strong defender of a convention. So in the sense that it's a reinforcement, it's strengthening international law, it's strengthening treaties, rules-based international order. So we have been a supporter of a convention, and I think that's more, at least in my experience. I'm not sure how much 12 plays a part or not. I mean, of course, it's an extremely interesting academic debate, and I think in some positions also, some states they do take a 12 approach, but I think they also take an approach whether you think that international law protects you, and that's why you want to develop in international law. And on the very last point raised by Abhinav, and the question of sovereign equality and the work of the International Law Commission, it's extremely interesting because, of course, not every state, because it's a limited composition. We're just 34 members, and of course there's a distribution by the different regions, and the statute says that the different legal systems have to be represented. So there's this also equilibrium between civil law, common law, the question of the different languages, and I think it's representative. I mean, where the ILC is not representative is in questions of gender, where we're still very short from parity, and we had elections recently, and we were hoping we could double the number of women, and we just augmented by 1 instead of doubling. But at least we're going to be 5 soon, which is already an improvement. But in terms of how the election process and also the composition of the commission, I think it does tend to contribute to an approach that certainly reflects the issue of sovereign equality, and also the interests of small, big states. The topics that we work on also reflect, I think, the common interest of states. I think it's very interesting, and I'll just end on that note. The topic that I'm working on as co-chair of the study group on sea level rise, it's very interesting because it was supported. It was supported by a large majority of member states in the Sixth Committee, and it's a topic that was driven, I mean, supported by all, but driven especially by small island states. And the fact that there was also a proposal by Micronesia, small island developing state in the Pacific, that the Commission took very seriously, and we also made our own proposal, shows that you know, the interests of all states, whether they're big or small, they're taken very seriously by the Commission. So I know there are other ways that we can approach this question if we talk about other topics, but I think that in general, I mean, the issue that I see the problem in terms of equality is not on sovereignty, but it's on gender. And I'll end on that note.
Thank you.
Professor Teles, it was absolutely riveting hearing you. Thank you so much for sharing your time and expert thoughts. We're so honored and delighted to be able to host you. You've opened not only your expert thoughts, but also your visions and possible scenarios for the near future. We are so thankful to you. We welcome you to our campus whenever it shall be possible for you to travel and for us to welcome you. Our gates of the university will always remain open for you and for your expert thoughts and visions for international law. Thank you so much for your time.
Thank you so much.
Thank you. Thank you.